Good evening, everybody. Lovely to see so many of you, some old friends and new faces amongst you all. And thank you for attending, those here in person and also those online. I've got a few announcements to make as the chair. My name's Mark Willers. I'm a barrister in Garden Court Chambers and known to some of you, all of you. What are we going to be covering tonight? Well, we're going to be talking about recent developments in Gypsy and traveller law, including those arising from recent challenges, very recent, some of them are a couple of years old now, to the planning definition, the use of wide injunctions by local authorities, and new enforcement provisions which were brought in by the previous government and were challenged earlier this year. The speakers will include me. I'll kick off with the planning definition case. Owen Greenhall, who will be joining us remotely on his sick bed. He's not up there at the moment. He's somewhere in the ether. Will be talking to us about the use of wide injunctions in the Supreme Court judgment in a case that many of us around this table were involved in. Ollie Percy, who sits to my far left, will be talking to us about the challenge to the Police Crime Sentencing and Courts Act provisions relating to gypsies and travellers. My colleague Stephen Cottle, immediately to my left, will be talking to us about a great victory in a case called Dean against Mitchell that he did with Chris Johnson, and Chris Johnson will be coming up at the rear to tell us something about all of those cases and more, and perhaps what we can learn from them and his great experience over nearly 30 years working for gypsies and travellers and to protect their rights. Telling stories. And telling stories. The odd story might be squeezed into his presentation. So without further ado, I'm going to talk about the planning definition. In order to do that, I need to get over there, get to the PowerPoint, so I'll do that. And then I'll give brief introductions to each of the speakers as they come up to deliver their presentations. So, can I begin by talking about come and sit down. There's a couple of seats over here. Never miss much. Really formalities. Okay. So, by the way, if I start coughing, apologies, I've got a bit of an infection. Nothing infectious. It's not a great thing to be presenting. So the case of Lisa Smith is one that I remember for a long time. It went up and down Dale. It was a real journey, and that word is used often. But I think we had about 7 or 8 judges dealing with the case overall. And it's a case in which, as you may know, the Court of Appeal ruled that the planning policy definition of the term gypsies and travellers, you'll note the reference to gypsies and travellers all in lowercase, which I think all of us in the room would say is a derogatory use of those 2 words. But that term was discriminatory and unlawful. And the reason it was discriminatory and unlawful was because in 2015, the government decided that it should be amended from the definition that originally was set out in the 2012 policy document, planning policy for traveller sites. Again, see the use of the lower case for the word traveller. Planning policy for traveller sites is a policy that contains all that you need to know as a planning decision maker, whether it be a local authority or a planning inspector on appeal, as to how gypsy and traveller sites needs should be assessed and how applications for planning permission for such sites should be determined. And in order to be able to rely upon that planning policy, positive in the main as it was, one has to show that one falls within that definition of what it means to be a traveller in planning policy terms. And the policy reads, or at least read in 2012, as follows. To fall within the definition, one had to be a person of nomadic habit of life, whatever their race or origin, including such persons who, on grounds only of their own or their families or dependents' educational or health needs or old age, have ceased to travel temporarily or permanently, but excluding members of an organised group of travelling show people, circus people travelling together as such. So that was the 2012 definition. In fact, it originated from a definition set out in what some of us will remember was Circular 1 of 2006, a previous iteration of government's planning policy. As I said, the definition was amended when the coalition government was taken over or superseded by the Conservatives in 2015. And the new definition removed the words "or permanently." So if we just go back to that old definition, you'll see that to comply with it, you have to cease travelling temporarily or permanently. So if you'd stop travelling because of old age, you could still fall within the definition. But in 2015, removing the words "or permanently" meant that gypsies and travellers that were forced to cease travelling permanently due to ill health or old age, they would no longer fall within the PPTS definition, planning policy definition, and as a consequence could no longer rely upon its policies when seeking planning permission for a site. Now, Chris and I and others realised when that definition change was suggested, and indeed when it was adopted, that it was discriminatory. We wrote about it, we blogged about it, we were outraged about it, as were the NGOs and all those who represent gypsies and travellers. And we looked in vain for a potential case where we could perhaps challenge the decision. Remember that, Chris? But we got a client, didn't we, at one stage? Eventually, she had to bow out because she was granted, I think, permission or given alternative accommodation. But thankfully, Lisa Smith appeared on the horizon. Lisa Smith is a Romany gypsy. She lives with her family in caravans on a privately owned site with temporary planning permission at the time. And then in 2016, an application was made by the landowner on her behalf to make the planning permission permanent. That application was refused by the local planning authority, despite, I should add, there being very serious health and welfare concerns, and particularly those relating to her two elderly, severely disabled sons. I say elderly, adult disabled sons. She appealed against the refusal of planning permission to the Secretary of State's planning inspector, but the planning inspector dismissed her appeal. That inspector found that Lisa Smith couldn't rely upon the positive planning policy contained in planning policy for traveller sites, because she had ceased travelling for healthcare reasons and didn't meet the definition of gypsies and travellers contained in that policy. So clearly, a decision taken based upon the definition, which everybody on this side of the bench and no doubt all of you agree was discriminatory. The case came to me via Keith Crabtree, who sits in the front row, who was then at Dayton Pierce Glynn, now at Public Interest Law Centre. And we drafted a review of that decision and put it before the High Court. And in that case, we argued that the decision taken by the planning inspector was flawed because it was based upon the definition, which was unlawfully, indirectly discriminatory against both elderly and disabled gypsies and travellers, those who cared for them. That led to something of a roller coaster ride through the High Court. The application for permission, you have to go through a permission stage first to get your case heard by a judge in the High Court, was refused on the papers by a senior planning lawyer who sat as a deputy judge. We then applied for permission orally, and I remember us going to Birmingham and Mr. Justice Swift giving us a very rough ride and dismissing the application pretty much out of hand. We then went to the Court of Appeal to try and get permission to bring the judicial review, and were granted permission on appeal. thankfully. And then we went back to the High Court for the substantive hearing, the hearing of the merits. And we came before a judge called Mr. Justice Pepperell. And that judge held that although the definition was discriminatory, indeed it was conceded as being discriminatory, it clearly affected elderly and disabled gypsies and travellers and those who travelled with them, and indeed predominantly those who cared for those being predominantly, I should say, women. That discrimination was nevertheless justified and lawful. As you might imagine, we didn't like that decision at all. We were very unhappy about it and thought it was wrong. And by that stage, I'd been joined, as it were, by a supporting act, but more than a supporting act. Tessa Buchanan had come onto the team. And I don't know if Tessa's in the room, but she added a lot of brilliant legal arguments to those that I was raising. And we put forward a very, very powerful application for permission to appeal. The application was granted. The case was then heard by the Court of Appeal. And again, I was very thankful that Tessa was able to marshal all my thoughts and improve upon them in the written submissions that we presented to the Court of Appeal. We then had a hearing before the Court of Appeal, and much to my surprise, the judges gave the barrister for the Secretary of State a hard time. And what the court concluded was that Lisa Smith's appeal should be allowed on all grounds. First, the Court of Appeal concluded that the judge had effectively reversed the burden of proof, requiring, that's Mr. Justice Pepperell in the High Court, requiring that Lisa Smith prove her case on the basis that she was bringing some sort of abstract or theoretical challenge to the policy. When we were arguing all along, no, that it wasn't abstract, it wasn't theoretical. It affected the decision that was taken in relation to her particular site and her accommodation needs, and indeed her family's ability to live in accordance with their traditional way of life in caravans. And the Court of Appeal agreed. The Secretary of State had conceded that the definition was discriminatory, and therefore the court said that the burden was on him to justify the discrimination. And there was no burden on Lisa Smith at all. The Court of Appeal also held that the judge was wrong to find that Lisa Smith couldn't rely on race discrimination as a ground for the challenge. It had been argued that because race hadn't been specifically pleaded, argued on the papers, it wasn't an argument that we could run. But the court, rightly in my view, said that there was an inherent element race in this case, particularly given the fact that we were concerned with the traditional way of life of gypsies and travellers and the ability to live it when challenging the definition. In addition, the Court of Appeal held that the judge had erred in his treatment of the legitimate aim, which one has to consider when considering a discrimination case, by focusing too much on the aim of the policy itself as a whole, rather than the aim of the definition. And the court were not convinced about what the aim actually was, said to be, having listened to the arguments put forward by the Secretary of State and read the evidence presented on his behalf. And finally, the Court of Appeal concluded that the judge, Mr. Justice Pepperell, had erred, got it wrong in respect of the proportionality exercise as to conduct when considering whether or not a measure is justified or discriminatory and unlawfully so. What the Court of Appeal said was whether the planning system taken as a whole is capable of being operated in an appropriate way, which is the way that the High Court judge had looked at it, was not the correct test. What matters was how the planning system operated in practice. And then the Court of Appeal proceeded to determine the case for itself and concluded that the definition was not justified. In doing so, the Court of Appeal concluded that it wasn't in pursuit of a legitimate aim. Whilst the stated aim was fairness, the evidence demonstrated the opposite. And the Court of Appeal said that the acknowledged likely effect of the definition change was to reduce the number of gypsies and travellers who can obtain permanent or temporary planning permission. And they said that could not be a legitimate aim. Secondly, and in any event, the measure was not proportionate in the Court of Appeal's eyes. They noted that the government's own public sector equality duty analysis, their own evidence was that the definition change could separate family members from each other, the elderly and the disabled from those who are able to travel around, those who might then get planning permission compared with those who would not because they wouldn't fall within the definition. It also showed that those most likely to be affected were the elderly and disabled and also potentially women, and that there was a risk of an increase in homelessness and unauthorised camping. This was all evidence of the Secretary of State's making, which we were able to rely on. And the Court of Appeal concluded that in its application of Lisa Smith's appeal before the inspector, that's at the planning inquiry stage, the effect of the definition was unlawfully discriminatory, and therefore the decision to refuse her planning permission must be quashed. Now, this was a challenge to a planning appeal decision. The court only had powers to quash the decision. It didn't have powers under that procedure to quash the definition. So what it said in the last couple of paragraphs of its judgment was that it would be for planning inspectors and local authorities to consider whether or not, when striking the planning balance in future cases, the application of the definition was justified. But what we know following this judgment is that a number of planning inspectors have looked at the decision and accepted that when it comes to the determination of whether or not gypsies and travellers comply with the definition, the definition itself is unlawful and discriminatory and ought to be given little, if any, weight. We know too that when it comes to the assessment of need by local authorities, they no longer rely upon this definition, this unlawful and discriminatory definition, and have had to reconsider their needs assessments, and so too have local planning inspectors on appeal. And thankfully, we find that as far as the government is concerned, good sense prevailed, published a revised version of the planning policy for traveller sites policy in December of 2023, in which the definition of the term gypsies and travellers reverted to the version that was issued in 2012. And so we now have again a definition which includes those people who may have, on grounds only of their own or their families or dependents, education or health needs or old age, have ceased to travel temporarily or permanently. And so people like Lisa Smith, families who have perhaps had to give up travelling permanently because of old age or ill health, because they're caring for people who are too old to travel or too ill to do so, can nevertheless rely on the planning policy that is in the planning policy for traveller sites document. So that's the rocky road, as it were, but fortunately we came out at the end of it with a successful result. And I wanted to just say two other things. There were others involved in the case, and one of them was the London Gypsy and Travellers. And Liberty were also intervening. So we had the support of not just NGOs from the Gypsy and Traveller field, but also from the wider justice field. Derbyshire Gypsy Liaison Group were also involved too. So thank you for all those who gave great support. Thank you to the great work that Keith did, and as I said, Tessa Buchanan, who kept on the straight and narrow in that case. And I'm now going to sit down and introduce the next speaker, if I may. And at the same time, ask Alicia if she could set this up. We're going to hear now from Owen Green, who's a colleague at Barrister at Garden Chambers. Yeah. He's joining remotely. Some of you may know him. Owen has a discrete interest in discrimination claims brought by gypsies and travellers. He's regularly instructed in claims relating to the provision of goods and services, often involved in the refusal of service in pubs and restaurants. And that work included working with me on the traveller movement against Wetherspoon's case, which many of you will have heard of. He also worked with me on the Dale Farm litigation, who remembers that some time ago. And he is also an authority on protest rights. And he's going to be talking to us about a case that he worked on with Chris Johnson and myself and others, which ultimately got to the Supreme Court, the case of Wolverhampton City Council against Person Unknown and others. I'll hand over to you. Oh.
Thank you, Mark. I hope everyone can hear me okay. I'm sorry if my voice doesn't hold up. I've got a bit of a cold. I'm going to try and share my screen. It's always a nervous stage in these kind of Zoom events, but I hope that should allow people to see the slides that I've got. And I'm going to talk about, well, really, two cases. The first is the case of Bromley and Persons Unknown, which is a case that Mark and Tessa did. And then I'm going to move on to discuss the Supreme Court decision in Wolverhampton. This really all concerns borough-wide injunctions. Those are injunctions which prohibit unauthorized encampments in all or virtually all parcels of land across a local authority area or borough, hence the name borough-wide injunction. They started in recent times around 2015 in Harlow, and then sort of snowballed, and a whole series of boroughs obtained such injunctions. In almost all cases, gypsies and travellers weren't represented at the hearings, and the Court of Appeal in the Bromley case remarked that that was something which was clearly of concern to them. But in the first case where the defendants were represented by Mark and Tessa in the High Court and later in the Court of Appeal in the Bromley case, that was the first case where the High Court refused to grant the injunction that was sought. And that decision was then appealed to the Court of Appeal, and the Court of Appeal upheld that decision. And what the Court of Appeal said, that they noted there were about 38 of these injunctions in place nationwide, and said it would be unrealistic to think that the widespread use had not led to something of a feeding frenzy in that area. And they pointed out two reasons for that. The first was that injunctions would force gypsies and travellers out of boroughs which had obtained injunctions, and that puts a corresponding greater strain on the surrounding surrounding boroughs, and that in turn then caused boroughs that didn't have injunctions in place to try to get them, to try to preempt that, and that just meant that the whole process spread across the country. The Court of Appeal upheld the decision of the High Court to refuse to grant an injunction, and these are all aspects of the High Court's reasoning which were upheld by the Court of Appeal. The talk I'm going to give now is very much a whistle-stop tour and is not going to be able to cover everything, but the Court of Appeal noted that the order was effectively a de facto borough-wide prohibition on encampment, and it really prohibited access to all public spaces in Bromley except cemeteries and highways, which were quite, for obvious reasons, inappropriate stopping places. The absence of any alternative sites in the borough was plainly relevant to the proportionality assessment of making an injunction. the court also upheld that the cumulative effect of other injunctions, so in other boroughs surrounding, was also a material consideration when deciding whether to make an injunction, and said that it's a matter for the local authority in the first instance to very carefully consider the temporal and geographical range of the order that they're seeking. The court noted the tension between the Article 8 rights of the Gypsy and traveller community and the common law of trespass, and pointed out that the obvious solution, as anyone working in this area knows, is that the provision, what's required is the provision of more designated transit sites. And the court held that borough-wide injunctions were inherently problematic. Essentially, they give the Gypsy and traveller community no room for manoeuvre. As well as upholding the decision of the High Court, the Court of Appeal also laid down guidance for local authorities that were seeking injunctions. The starting point was the fact the court noted that the Gypsy and traveller community had an enshrined freedom not to stay in one place, but to move from one place to another. So their nomadic way of life needed to be facilitated, and an injunction which unreasonably stopped that effectively amounted to a breach of the European Convention and the Equality Act. Any local authority seeking an injunction had to satisfy at least these three requirements. The first is that it was of the utmost importance that there is engagement with the Gypsy and traveller community. It was very important that welfare assessments, particularly in relation to children, are carried out. The court noted that an up-to-date equality impact assessment is always important, and emphasised that the impact of injunctions will vary from borough to borough, and it's certainly not a one-size-fits-all, and it also has to be up to date. And the Court of Appeal essentially said that if those requirements are not properly demonstrated, then the High Court ought to refuse applications for an injunction. So that's how things stood in 2020. And at the same time as the decision in Bromley, there was some developments in the law in relation to injunctions more generally. And there was a case of called Canada Goose against persons unknown, which was a protest law case where a shop had tried to seek an injunction restraining protests from taking place outside it. And a judge in the High Court, Mr. Justice Nicklin, had set out a whole range of essentially procedural requirements which had been breached in that case. And that decision was appealed to the Court of Appeal, and in broad terms, the Court of Appeal upheld that decision. So all that development had taken place in the protest context, the Gypsy and traveller context injunctions hadn't really been updated to take account of that. Local authorities had effectively just allowed injunctions to continue. And this was going into COVID times, and perhaps things weren't getting quite the same level of scrutiny that it might otherwise have done. But that then stopped in the case of Enfield and persons unknown. And that was a case which is the first time that I met Chris Johnson virtually, because he was taking part in a telephone hearing in front of Mr. Justice Nicklin. And Mr. Justice Nicklin was very concerned about the approach of the local authority in terms of the injunction that it had obtained. And Chris and I made representations in that hearing, and Mr. Justice Nicklin refused to extend the injunction that was sought in that case, and also called in to the High Court as many of the existing wide injunctions that he could identify. And it was something in the region of 40 odd injunctions that were called into the High Court for a review in front of Mr. Justice Nicklin. He held that those injunctions didn't satisfy the requirements that had been set out in Canada Goose, and essentially that final injunctions of that form couldn't be made. And that was his ruling. That unsurprisingly, was appealed to the Court of Appeal, and that was in the case of Barking and Dagenham. That decision was held in front of the Master of the Rolls, and the Master of the Rolls overruled the decision of Mr. Justice Nicklin, so effectively upheld the idea that in principle injunctions against persons unknown could be made in a Gypsy and Traveller context. And the decision is quite clearly contradicts the guidance of the previous Master of the Rolls in the Canada Goose case. So we had a situation where there were two Court of Appeal decisions quite obviously in conflict with one another. And that meant that the what had now been called the Barking and Dagenham case, that was appealed to the Supreme Court, and that is what became the Wolverhampton case. That was one of the conjoined appeals in Barking and Dagenham. And that was an appeal that was brought by three interveners: London Gypsies and Travellers, Friends, Families and Travellers, and the Derbyshire Gypsy Liaison Group. They together brought the appeal. It's important to note, I think, that in order to bring the appeal, a protective costs order was sought by the Supreme Court and was made by the Supreme Court. And that's unusual because on its face, this is simply civil litigation rather than public law. And so that was an extension of the usual principles. But the question the Supreme Court was dealing with was obviously a fundamental question, and that is whether final injunctions can be made against newcomers, that is, people who aren't party to the litigation at the point at which the order is made. And the argument that was put forward on behalf of the Gypsy and Traveller groups who were seeking to suggest that this couldn't be done was that this was really not like any other form of legal remedy. It was an unwarranted extension of injunctions into this area. And the Supreme Court agreed, yes. They said that it's not possible to fit this kind of injunction into the usual category of legal remedies. It's a wholly new form of injunction. But rather than say that that was a problem and it should never be done, the Supreme Court ruled that that was acceptable, and this was just a form of legal remedy that now exists. So you can now have final injunctions made against persons unknown. They are binding against the whole world, including those not party to the proceedings. As well as upholding the decision in principle that injunctions should be made, the Supreme Court did look at some of the guidance as to when and what requirements there are for making this kind of an injunction, particularly in the Gypsy and Traveller context. And if the decision in principle that persons unknown injunctions can be made is a disappointing one, there is a little bit more room for optimism in terms of the protections that the Supreme Court saw. And what the Supreme Court said, that any applicant for the grant of an injunction against newcomers in a Gypsy and Traveller case has to satisfy the court by detailed evidence that there's compelling justification for the order sought. And that requires consideration of whether the local authority has complied with its obligations to provide lawful stopping places, whether it has exhausted all reasonable alternatives to an injunction, whether it's taken appropriate steps to control unauthorized encampments using other measures. And in relation to that, the Supreme Court was particularly interested in the use of bylaws to restrict unauthorized encampments. And the consequences of breaching a bylaw are clearly far less severe than the consequences of breaching an injunction, and the potential for a more detailed fact-specific analysis of the reasons for an encampment are far easier in the context of a bylaw than using the more blunt tool of an injunction. And the Supreme Court also said that there has to be a very strong probability that a tort is going to be committed and that it will cause real harm. And all of this needs to be supported by clear evidence. the Supreme Court essentially upheld most of the guidance from the Court of Appeal in Bromley, and noted that they had considerable doubt as to whether it could ever be justifiable to grant a gypsy and traveller injunction directed to persons unknown, which extends over an entire borough or for significantly more than a year. Emphasised that it's an exceptional remedy. It has to be a proportionate response. And the Supreme Court considered that an injunction which extends borough-wide is likely to leave the gypsy and traveller communities with little or no room for manoeuvre. That's the same turn of phrase which was used in the Court of Appeal in the Bromley case. The Supreme Court also emphasised that it's important that local authorities give advance notice of an injunction application to groups which represent gypsies and travellers. It's noted the importance of having both sides of the argument presented to the court rather than simply hearing from the local authority alone. The Supreme Court could see the benefit, as they said, of giving cost protection in the High Court, in the same way that the interveners had cost protection in the Supreme Court, although the Supreme Court didn't go into the details as to the circumstances and the precise mechanisms by which cost protection should be given. It should be noted in this regard that in the protest context, one development has been the use of CPR 40.9, a provision of the civil procedure rules, to allow those who aren't party to proceedings but are affected by an order to make representations in injunction cases, and to gain some perhaps limited protection in costs. And that's certainly something which it is worth exploring in a gypsy and traveller case. But beyond the cost provisions, the Supreme Court were quite clear that the consideration in gypsy and traveller contexts are not identical with those in protest cases. So this isn't an area where you can simply read over decisions on protest cases and automatically assume that the same factors are going to be relevant in a gypsy and traveller case. That is really the state of the law as it is now. The decision of the Supreme Court came in at the end of last year. Some of the local authority injunctions have been coming up for renewal in the High Court. My understanding is that there haven't been any that have been contested to any great degree, and there isn't any significant authority on how the requirements from the Supreme Court are going to be implemented. But that's obviously where the focus is going to be, and it's a need to thrash out the details of this and try and pick up on the protections that the Supreme Courts have given as far as they can assist. That's all I wanted to say.
Very much, Owen. That was brilliant. I didn't introduce him as has been said about him in various legal tomes. A rising star of the bar, a clear silk of the future, a formidable trial advocate. And having worked with him on many occasions, I can attest to that. And that was a great summary of what is actually quite a complicated area. So thank you very much for that, even from your sickbed. Thank you for giving us your insight. So can I now pass over to another brilliant advocate, winner of the 2023, I think it was, the 24 Legal Aid Law Award. Ollie Percy, who sits to my left, is ranked as a Tier 1 rising star in the Legal 500 for his education and community care practice. He acted for the successful claimant, Wendy Smith, in the challenge to the Police Act enforcement measures, which targeted gypsies and travellers. He acts for children, young people and families where education law issues arise, and is committed to addressing discrimination in the education system. He's a trustee of the Education Law Association, sits on the School Inclusion Project, and provides pro bono support to Southwark Law Centre's School Exclusion Unit. And he's going to be talking to us about the Wendy Smith case.
Thanks very much, Mark. So this is the latest in Chris and Mark's greatest hits, which we're going through today. I say greatest hits, only the last 2 years, but which shows just what a remarkable contribution they've both made. I'm hoping I understand how to work this. Good. Yay, good start. So, the case of Wendy Smith against Secretary of State for the Home Department, which was a judicial review, which, like some of the cases that you've heard about already, had a bit of a convoluted procedural history, which I'll come to later. But this was a challenge to new provisions aimed at criminalising the Gypsy and Traveller way of life, and creating no room for manoeuvre by increasing the criminalisation of trespass for Gypsies and Travellers using unauthorised encampments. The fundamental issue at the root of this, like with the cases Owen has spoken to, is the lack of authorised encampments. But that did not stop the previous government introducing legislation that criminalised instead of supported and addressed the underlying issues. So this was aimed at Section 60C and Section 61 of the Criminal Justice and Police, Public Order Act 1994, inserted by the Police Crime Sentencing and Courts Act 2022, which was Priti Patel's landmark piece of legislation. We miss her not. So who was Wendy Smith, or who is Wendy Smith around? That's on the screen. She was someone affected by this because she's a Romany Gypsy, he lived in a caravan and had never lived in bricks and mortar accommodation. Local authority has allowed her ex-partner and son and daughter-in-law to reside in a lay-by since the start of the COVID-19 pandemic. Prior to that, she would have been subject to frequent evictions. She was concerned these powers would impact on her. And she had, like many other Gypsy travellers, because of the shortage of designated transit sites and other authorised encampments, had no choice but to remain there. So Wendy was the claimant, the defendant, Secretary of State for the Home Department. By the time of the hearing, it was no longer Priti Patel. It had been umpteen others by that stage. As I've mentioned, these are the provisions that got amended. The crux of it was the new offence of residing on land without consenting with a vehicle, which was Section 60C provision, as well as a strengthening of existing powers, notably Section 61, to restrain unauthorised encampments. And crucially, and this links back to the no room for manoeuvre point, no return periods extended from 3 months to 12 months. So if you're getting lots of these notices and it's adding together 12-month periods where you can't come back into an area, 3 months to 12 months is a very significant change, which reduces room for manoeuvre. So what were the concerns about these provisions? Well, I've already gone through some of them, but I'm going to take you through some of the evidence that we had in support of this claim. And I should say at the outset, this was a claim in which Chris was instructing solicitor and Mark was leading counsel, but we were supported by a raft of organisations, most significantly friends, families and travellers, who provided evidence in support of the claim, as well as an intervener, and their counsel team included Stephen Simlet, King's Counsel, who is at the back, and Nadia Amara, and they were instructed by Faminda, who's also at the back, and also at CLP. And we were very grateful to have their support. Liberty also intervened and provided valuable support. So just doing a quick canter through some of the evidence and what the concerns were. The Joint Committee on Human Rights, when scrutinising the legislation as it passed through Parliament, noted significant concern with the justification behind the new offence, and considered that there were other ways of tackling unauthorised encampments. For example, a statutory duty on local authorities to provide adequate authorised encampments. So fixing the root cause of the use of unauthorised encampments rather than criminalisation. The provision of more authorised sites would also benefit landowners who are quite rightly concerned about the present situation. the National Police Chief Council, so it's a diverse coalition of people who were against this legislation. The lack of sufficient and appropriate accommodation for gypsies and travellers remains the main cause of incidents of unauthorised encampment and unauthorised developments by these groups. So this criminalisation isn't solving the problem, it's unnecessary, and they have really, as a government, the government needed to grapple with the lack of authorised encampment. We've delved into the systemic discrimination experienced by gypsies and travellers, which will be well known to most of the people in this room, including a 2017 survey, which found that 91% of respondents had experienced discrimination and 77% had experienced hate speech or hate crime. The 2023 Centre on the Dynamics of Ethnicity published its Evidence for Equality and National Survey report, which found that 62% of travellers had experienced racially motivated assault, higher than any other minority group in the country. So these criminalisation provisions were set against a group that was already being targeted and experienced structural discrimination. So we were concerned that this was another layer of discrimination and targeting above and beyond the structural discrimination set out previously. We also drew upon the Council of Europe's Advisory Committee on the Framework Convention for the Protection of National Minorities. And as highlighted in bold, criminalisation of unauthorised sites and the potential to seize property has sown fear among communities. The Advisory Committee considers that any benefits to wider society resulting from these measures have not been adequately substantiated, aka they can't be justified. So this was not a new innovation, the provisions that were being put forward in this legislation and then passed in this legislation. As Friends, Families and Travellers noted in their intervention, and very helpful intervention, the impugned statutory provisions were expressly modelled on Irish legislation from 2002, which many people here will also be familiar with. The evidence of how those provisions had operated in practice was also valuable for us to draw to the court's attention, and shows quite striking negative impacts on gypsies and travellers exercising their nomadic way of life. And the Irish traveller movement attributing the criminalisation of trespass as being largely responsible for these substantial decreases. So we've seen it happen before, and it looks like it's happening again. A 2019 report similarly noted the significant adverse impacts of the Irish provisions. So what was our legal challenge? Well, you've already heard about Article 14 in previous presentations. I am not going to go into the law in any great detail because actually the law here was largely not in dispute, and it was accepted that we got to the final stage that the court needed to consider, which is that of justification. So we had made out what's called our prima facie case, that this was a racially discriminatory legislative provision, and it was accepted that that was at least indirect discrimination, and race discrimination required weighty reasons because it is a suspect and a particularly pernicious form of discrimination. And so the battleground is, as is the case with many Article 14 cases, is the last stage: can it be justified? The burden for justification is on the government. Could the government show that these new measures were justified, and could they put forward weighty reasons for them? So the crux of our case are foreshadowed. Provisions were excessive and not up by meaningful action by the government to address what is the fundamental problem, which was the real cause for unauthorised encampments. And the legislation was purportedly aimed at this, but criminalisation does not magic up new sites. The criminalisation of unauthorised encampments, the dearth of authorised permanent and transit site provision, and other measures such as increasing use of injunctions. So we very much linked back to this room to manoeuvre point that Owen mentioned, because the Wolverhampton case had been handed down very shortly before us. So this is the judgment of Mr. Justice Swift, and I've extracted the two key paragraphs and then a further paragraph. So, spoiler alert, we got a declaration of incompatibility, and I'll explain what that is in a bit more detail later, in relation to part of the challenge. So, the claimant, and Mr. Justice Swift has said, and this is not a particularly claimant-friendly judge, one might say, the claimant submits that the decision to extend the non-returns period, so this is the 3 to 12-month period that I spoke to at the beginning, is largely unexplained. And that the mismatch between the 12-month period and the 3-month maximum stay at a transit is a matter calling for explanation. Because, as I mentioned earlier, if you have 12-month periods, it substantially reduces the room for manoeuvre, much more so than 3-month period, because once the 3-month period is expired, the land becomes available. Is a matter calling for explanation, as it means that gypsies will no longer be able to avoid the risk of criminal penalty by resort to transit pitch. The position might be different if transit pitches were readily available. Well, sorry to sound like a broken record, but yes. Moving between several different pitches over the course of a 12-month period would be a feasible option. But the evidence shows this is not the claimant's submission is that the increased protection to landowners given by the 12-month no return periods places a disproportionate burden on gypsies. It expands the scope of criminal penalties and at the same time makes it more difficult to comply with the law. So, I accept this submission. Hurrah! The point here is not simply that the no returns periods have been extended. That of itself does revisit the balance between the property rights of landowners and occupiers and interests of gypsies. And you'll be unsurprised that the argument by the other side focused quite heavily on this. Think about the landowners. But if this point stood alone, the likely success of the submission that the change produced a disproportionate outcome would be in the balance. The matter that is decisive in the claimant's favour is that the extension of the no return period of itself narrows the options available to comply with the agreement. Resort to a transit pitch will no longer suffice as a maximum stay on a transit pitch is 3 months. The undersupply of transit pitches renders it much less likely that the opportunity exists to move from one to another. In this way, extending the no return period not only puts gypsies at a particular disadvantage, but also, and of itself, compounds the disadvantage. So that judgment has to be set in the context of all the submissions that were made earlier about the wide chilling effects. So while we weren't wholly successful in attacking Section 60C, the new measure, we did get this declaration of incompatibility in relation to the 3 to 12 months return period, and which wasn't only in Section 60C, it was in the existing powers already, 3 months to 12 months. The guidance includes, and the judge was clear that the statutory guidance needed to be an effective safeguard and applied properly by those using it. So the guidance includes a requirement to follow the operational advice issued by the National Police Chiefs Council. This ought to be sufficient to filter out the possibility of malicious or discriminatory action by legal occupiers of land, yet to be seen. So a declaration of incompatibility is granted, and so a declaration of incompatibility is a very unusual remedy for the High Court to grant. It pings the legislation back to Parliament for reconsideration. It doesn't require the legislation to be amended. We don't have a sort of US-style constitutional strike-down provision. However, it's very rare, a handful per year. So to achieve this is a very significant change, and it provides an opportunity for the new government to revisit the provisions generally, which we hope is picking up. I foreshadowed at the beginning that this was a bit of a bumpy ride, and that was, to put it mildly. Amazed we got to a final hearing, and amazed we won. We were refused legal aid. We had to lodge without legal aid, which is a bit hairy, and seek a stay. We were refused permission on the papers. We were then refused permission at an oral renewal hearing, and I've never seen this happen before, and I don't think any of my colleagues have seen this happen before. But Chris and Linda and all of us were, and Mark were, eyebrows raised. So we went, the case was heard in Birmingham, we had the oral renewal hearing. So the way judicial review works is you have 2 bites of the cherry to get permission. Papers refused, oral renewal hearing. Mr. Justice Garland at the hearing, the High Court judge was like, no, goodbye, after hearing oral submissions. But then we got an email a few days later saying the judge wanted to hear from us again, which is a very good sign if your starting point is you've been refused permission. And so we were like, okay, this is weird. Don't want to get our hopes up too much. But then he had changed his mind and he granted permission, albeit a little bit grumpily, because he said, I guess it does just about part of the threshold of permission, and then we won. So happy days, a really brilliant achievement for Chris and the team, and the amazing supportive work from Gypsy and Traveller grassroots organisations. A number of people that showed up at the hearing to support the case. Some of them are here today. Was really gratifying. So yeah, a really brilliant judgment, and it was a real privilege to be able to learn from and work with Mark and Chris. Thank you very much.
Thanks, Ollie. And there was another brilliant exposition of, again, a tricky case. And, you know, you can perhaps appreciate how lucky I am to be working with juniors like Ollie and Owen and Tessa, who I'm not sure is here. One of the other things to say is that we also had the assistance of Richard Drabble, Casey, Landmark Chambers, who's done a lot of work with us for Gypsies and Travellers in the past. And so, in fact, I think he and Ollie were the ones who managed somehow to persuade Mr. Justice Garland to think again. And without that input, I think we would have not got before Mr. Justice Swift, what turned out to be a pleasant the days in front of him, much to my surprise. So, moving swiftly on then, we have now a presentation from Stephen Cottle, who is an expert in social housing, planning and property. I hear he's one of the foremost social housing lawyers, certainly what Legal 500 would say about him. And he's not just ranked with Legal 500, but also Chamber Partners for his work in social housing and in civil liberties and human rights. Stephen's work in planning law includes defending enforcement proceedings and challenging the grant of planning permissions based on environmental impact, particularly in the context of Gypsy and Traveller sites. He also specialises in low impact development and community-based sustainable land uses, and again, very much with the expertise in Gypsy and Traveller rights cases. Remember that he was counsel in both two of the kind of the biggest cases in this field, together with CLP, Community Law Partnership, Chris and his colleague Angus, known as Porter number 1 and Porter number 2. Two cases involving a family who were effectively being forced to leave their land by South Buckinghamshire District Council, from what I remember. Those two cases went to the House of Lords, hence the name Porter number 1 and Porter number 2, and they are, you know, pretty much up at the very top of Chris's top 10 cases, and no doubt Stephen's too. So without further ado, I'm going to invite him to speak about another great stirring victory that he had with Chris in a case called Dean against Mitchell, and he might have 1 or 2 observations about 2 of the other cases. Over to you, Steve.
Okay, well, thank you. I think on the point really of the Wendy Smith case, just hearing Ollie going through that case, and what was incompatible was the prohibition on being able to return after the 3 months. And the context to that is the lack of transit provision. If people are only allowed to stay on a transit site for such a short period of time, why isn't there symmetry between the provisions and the time on transit sites? And thinking about what Owen was talking about and the Wolverhampton case, where the Supreme Court said the availability of transit sites is also important in providing short-term or temporary accommodation and travellers moving through a local authority area. An absence of sufficient transit sites in an area may itself be a sufficient reason for refusing a newcomer injunction. And you think about all those accommodation assessments which are being adopted up and down the country by, I don't know, 340 local authorities we've got here, where the provision for transits is simply kicked down the road. There's no assessment of transit provisions, and there's no result to do anything about it. So I think that on the heels of these two recent judgments, there is probably a stronger case for challenging a local authority which is adopting an accommodation assessment, which just isn't fit for purpose because it doesn't actually meet the ethnic accommodation requirements of groups within its borough. And I think that's an important point, not least, of course, there's other challenges on accommodation assessments because they never drill down into affordability or tell you how many pitches are needed available at social rents. They simply have a one-size-fits-all for private provision only, without any drilling down to the socio-economic accommodation needs. And the other point that I wanted to pull out from the Smith case is how really very important it is to all of our planning work. I was doing a case in Surrey Heath in front of Nick Davis. I was doing a case in South Gloucestershire in front of Inspector Darren Henley. I was doing a case in Tandridge in front of Miss Mad, I've forgotten her first name, recently. One was scheduled monuments and undesignated archaeological remains. Another one was flooding zone 2 and breach of the exceptional chest. And the other one had really significant highways issues. And we won all of those. But the point really is about the materiality of the Smith case. And even in the High Court, where a planning authority go to court on the basis you've just lost in front of the Secretary of State, and here's a decision which has refused you permission. And the High Court judge says that she's refusing the injunction requiring people to leave the land because the Smith case represented a material change in terms of the assessment of need, because of course you've excluded a number of people you should have counted. And so therefore your provision is set at too low a mark because you're undercounting. And so really the extent of that Smith case cannot really be properly estimated. It's very, very wide. We know that race equality is a material consideration. We know that disability is a material consideration in planning decisions. And we also know that the Smith case is adding strength to the arguments on need. So I'm here to talk about a case called Dean and Mitchell. And that's reported in the Housing Law Reports last year, 2023-44. And this was a case in which landowners allowed Mr. Mitchell to move onto their land in about 2001, 2002. And this is the bit really, that on the strength of that, they applied for a certificate of lawful use. And certificates of lawful use can be applied for under section 191 of the Town and Country Planning Act 1990 if any existing use or buildings or other land is lawful, or any other matter constituting a failure to comply with any condition or limitation is lawful. And it would be lawful if it's been there for longer than a period that you can enforce against. And so Mr. Mitchell had been there more than 10 years. And the landowners then applied for a certificate of lawful use and got one, and the next day issued in with a notice to quit. So their land now has the benefit of a planning permission. One of the important features of this case, and another case that I'm going to mention very briefly, is that the certificate of lawful use had always been seen in the old days as just a sort of like an immunity from prosecution, but not actually seen in a positive sense, which is that it's planning permission for the purposes of site licensing. And this case, where the Secretary of State was well represented, and the other case I'm going to mention in a moment, both cases, High Court and the Court of Appeal, deciding that the certificate of lawfulness of existing use not only is a certificate of lawfulness, but it is, for the purposes of the Mobile Homes Act, the relevant planning permission under section 1 of that act. So he gets issued with a notice to quit. Was there security? Did he have to leave? That's how the question arose. And it was Chris who was handling the case. And the purpose of the Mobile Homes Act was to confer security on those living on land which has planning permission. So we're in a caravan. We're allowed to station it on land, which has planning permission. So what's the problem? And the court judgment is remarkable because of the depth it went into the Hansards and debates that were going on in the House of Parliament, House of Lords at the time of the legislation. We went back to the 1960 Act, the 1968 Caravan Sites Act, the 1975 Act and the 1983 Act. And it was remarkable that so much material, parliamentary material, was used. And it was used on the basis that it was necessary to identify what mischief the provisions were intended to remedy. And it was justified to measure the submission that exclusion of the likes of Mr. Mitchell from the protection was the result of an informed legislative choice. So we have a huge amount of material in this judgment about the origins of the Mobile Homes Act legislation. Now, the problem in Mr. Mitchell's case stemmed from a Court of Appeal decision, which had held that the Mobile Homes Act can only apply if there was planning permission when the agreement was entered into. And my client, Mr. Mitchell's agreement, was entered into about 12, 15 years before he got planning permission. And we went into this in great detail. And what we found was that in 2001, the Labour government had accepted a recommendation that agreements should be supplied in advance. And this was a measure of consumer protection, so that people in a weaker bargaining position shouldn't have terms that they're unaware of, that they sign up to without realizing what they're signing up to. So you had to give people the agreement 28 days before they entered in, before they took possession, before they moved on, before they bought their mobile home. And what was found by the High Court is that these provisions in the Housing Act 2004 was the tail that was wagging the 1983 Mobile Homes Act dog, because my client, Mr. Mitchell, couldn't get mobile home security because he didn't have planning permission before he got there. And so the fact that he didn't have planning permission disqualified him from being secure under the Mobile Homes Act, because he wasn't given an agreement under the Mobile Homes Act, as was required by the law, when he entered onto the land in 2001. So we had this conundrum. And the consequences are bizarre, because, of course, if my client had left the day after planning permission was obtained, and they had allowed some friend to move the caravan onto the similar pitch, they would be protected because their agreement is entered into after the grant of planning permission. So what is the great pressing social need for Mr. Mitchell not to have security of tenure if you could let somebody in the day after who would have planning permission, and you could have somebody who's been in occupation for 20 or 30 years, and the planning permission is obtained the day before they signed their agreement, they're secure, and the planning permission is obtained the day after. Are you telling me that 20 or 30 years they don't have security of tenure, if the purpose of the legislation was to confer security of tenure on people with caravans on land which has planning permission? And so we went uphill and down dale on these arguments, and some judges obviously could go against you on this on the basis that it disincentivizes people to enter into agreements, and they should first check whether or not there's planning permission. And we were arguing, well, actually, the whole legislation is premised on the mobile home owner being in a weaker position, and it being very difficult to find out what the planning permission is when you're being offered the site by the park owner. Anyway, the short point was that the judge decided that it was disproportionate for Mr. Mitchell not to have security of tenure. Where, of course, if the case had come to court before the 2004 Act amendments had been introduced, he would have had security, because the need to serve the agreement 28 days before you moved onto the land only came into force after the 2004 Act. And so you had that period from 1983 to 2004 where it wasn't considered to be a problem. And so it was disproportionate for him to be denied security because of the severity, the impact that had on him in terms of loss of the home. And the loss of the home is important if you don't have the ability to go to court and have the proportionality of your eviction being decided by an independent tribunal. So the way around the Murphy case stemmed from a close analysis of the Mobile Homes Act. And on that point, I just wanted to mention another recent case, which I was in, which was Ting Dean Marinas and Jan Jaffe, which we argued in early June and concluded with a judgment in July 2024 in the Court of Appeal. And this was an example, again, of statutory interpretation, digging down to see what the purpose of the legislation was. And the client was given an agreement to moor a vessel. And you might be wondering why I'm talking about this case, alongside a jetty on a gravel pit. But in fact, it was a statutory Willoughby caravan on a float, and there are ramps. So you could roll the caravan off and take it on holiday. It was a completely intact caravan, its wheels and everything. And it was on a float, and we were talking in the first tier tribunal of what if the army had put an entire gravel pit, covered it with pontoons, and put a fleet of caravans on it, with those caravans stopped being caravans because of where they're parked. So we were arguing that the Mobile Homes Act had to be taken in terms that you look at the statutory provisions and you have to very closely apply the wording of the statutory provisions to the fact of the case. And what was my client living in? She was living in a caravan. And the terms of the Act apply to somebody who's allowed to station a caravan. Are they on land? Well, we accept that land is land covered by water. So of course she's on their land because they're trying to evict her because she's alleging she's a trespasser. So that wasn't a problem. So she's got a caravan on their land. And the next point is whether or not she had planning permission for it. And this is where the case got into difficulty because there was a certificate of lawful use that had been granted on the basis of it being a breach of condition, because there was a condition in the planning permission originally which prevented holiday use. And she got a certificate of lawful use because there had been permanent residential use, not by her, but by her predecessor title, who she built the mobile home of, for over a decade. And so there was a certificate of lawful use. And Ting Dean Marinas were basically saying that there was a description of planning, which was for houseboats. And that was a functional limitation in the description of planning permission. And the certificate didn't have a knock-on effect on the functional limitation. And I was arguing the Mobile Homes Act, Section 1 is satisfied because you've got a caravan and it's not in breach of planning control for permanent residential use. And they were saying, well, you haven't got a relevant planning permission because the planning permission was something different. And there we move into a common theme, which is areas of interpretation. And when it comes to statutes and when it comes to contracts, there's a sort of gradation of different approaches by the courts. And the starting point in the Lambeth case, which you may be familiar with in planning terms, is the natural and ordinary meaning of words used in the particular statutory context in the light of common sense. And so they've got a traditional approach to statutory construction. And that was the problem in the Mitchell case. The first case I was talking about was this decision of the Court of Appeal, which just looked at the effect of the 2004 Act and said, well, you can't possibly have security of tenure because the Act can only apply if you're given an agreement 28 days before you move on to the land. So therefore the Act doesn't apply. They were just adopting a conventional approach. And then you have a situation where there's an inequality of bargaining power. And we saw it in the Uber case, and we've seen it in housing in Street and Mountford and many others, AG Securities and Vaughan, where David was in. And that was where the House of Lords said the Court of the Tribunal should consider what was actually agreed. And so the Court of Appeal in Tingdy and the High Court in Mitchell are looking at the substance of actually the reality of what's going on. What's the legal effect of what's taken place? It doesn't matter about the labels. And that's why the Tingdy case is interesting, is because you've got a different description of planning permission. You've got a planning permission for a houseboat, but the houseboat, in fact, comprised a caravan on a float. And it was there retrospectively at the time the planning permission was granted. And so it's an interesting point. And so coming back to all of these cases, what the common denominator is really the importance of procedural protections as part of Article 8, because when we're arguing in Dean Mitchell, it was incompatible, saying it's a breach of Article 8. And in the Tingdean and Yaffe case, we're talking about security of tenure as otherwise affecting Article 8. It's those procedural protections. And that made me think that actually it comes back to the Connors case and Keith Lomax, who should be here with us today, who recently died. He was a huge player in our field. And I just wanted to read a poem of his because he was so important and then did so much work with us. Endgame. Suddenly looking down the barrel, on high alert as the doctor explains, this is serious, possible internal bleeding, clots in my veins, the tumour presses, a life extinguisher, it could even be tonight. How am I? Okay, honest. I don't for a moment feel other than okay. I can't imagine being snuffed out, just like that, right now. Quick, write a poem, might be the last. Intensity, some desperation to do and say, those final acts, wishes, expressions, catch up on missed opportunities, to make sure what I mean is love, love, love. I'm not alone, I'm deluged with love. Family, friends, and funny word colleagues break down and breach borders and boundaries. We are in this together. I will leave you together, sadly unable to be with you. Good memories will hopefully ride the saddle into the sunset. Never be afraid to laugh, with me, yet without me. We've had fun. It's power unbearable, unbeatable, like the drums and tunes we share, with mixed messages of struggle, humanity, and joy. Turn up the volume, play it loud, life matters. So what I'd say is we carry on being a bit more Keith.
Puts me in mind of other solicitors who have worked with Gypsies and Travellers over the years, like Peter Kingshill, Jeremy Brown, who wonderful work for Gypsies and Travellers over the years. And again, we're real trailblazers. But we're now going to move on to another one of those trailblazers, a true giant in the field, who is still with us. I do hear rumours that he's retiring, stepping down from the partnership at Community Law Partnership, as I read on the website. Surely that must be some mistake. As you will have heard already, he's one of the few solicitors, I think, who could probably claim to have been to the Supreme Court and House of Lords on more than a handful of occasions, in many of the leading cases involving Gypsies and Travellers, and we on this side of the table have had the privilege of working with him and getting his great guidance in those cases, being instructed by him. He's a co-editor with me, but also co-author with a number of people, again, on this table and elsewhere, of the LAG book, Gypsy and Traveller Law. He conducts training exercises, writes articles and blogs for legal action and other publications. He's also a member of the Free Tibet campaign. Get away without mentioning that. And the final thing to say about him is that he's a great storyteller. Having said that, we have got drinks and food downstairs at some point, so I'm just putting him on notice. I don't want him keeping you here because you'll be eating into our drinking time. But over to Chris Johnson. Thank you.
As has been my experience throughout my career, I can never rely on barristers in terms of their time restriction. Should be about half an hour, rather about 3 hours later. The great thing about these presentations, the wonderful presentations, right, from the point of view of Mark and myself, is that it makes it sound firstly like we win our cases, and it also makes it sound like we frequently go to the Supreme Court. In fact, I'll give you one example, since I'm now kind of reduced down to just a few stories now. And don't worry, not too many, because I know you're all dying for a drink. Of one case, which is probably a much better example of the cases that I've dealt with over many years, where the judge decided, and in fact, I was there with my client and also someone who was helping my client, who is actually here tonight, but I won't mention his name, who was sat next to my client behind me. And the judge very kindly, in a sense, very kindly, but before he did an extempore judgment, in other words, he decided to make his judgment there and then at the end of the presentation of the case. He said to my client, "I'm afraid I'm finding against you," which was nice in the sense that he told her what the result was. And so he started droning on, and I started scribbling away. And I heard behind me, I heard I'll call my great friend, the worker. I heard my client say to the worker who was helping her, "I hope Chris," sorry, to start with, I heard the worker say to my client, "I hope you're not upset about the decision." They were whispering to each other. And the client said, "It's okay, I knew I was going to lose, I could tell I was going to lose." And then scribbling on, and then I hear another whisper behind me, and it's my client saying to whoever, "I hope Chris is not upset." I heard her say to the client, "It's okay, he's used to being hammered." It's a much better description of the situation. I'd like to say very quickly, and I will make them much quicker than I intended to, which is I wanted to kind of do a look to the past and then a look to where we are now in terms of trying to, because I am retiring soon, and to hopefully give some ideas maybe to great campaigners in the field, Derbyshire Gypsy Liaison Group, Friends, Families and Travellers. We've heard of many of them, London Gypsy Travellers, and the great lawyers in the field, such as my wonderful colleague Parminder at the back, who's a far better lawyer than I am, and continues doing the great work with Travellers, and Mr. Coffrey down the front here. And that was when the Criminal Justice and Public Order Act 1994 took away the duty to provide sites that was contained in the Caravan Sites Act 1968. And at that stage, that was the birth of the Travellers Advice Team at the firm I work at, Community Law Parliament, because the local authorities and the police went at it with great gusto, and they were evicting Gypsy travellers right, left and centre, and very quickly and without any real due process. And it appeared that this was a crunch moment for whether all those Gypsy travellers who had managed to continue with roadside existence, despite the lack of transit sites that we've heard about, and Stephen put across so well. I thought, myself and my colleagues, I then worked at a firm called McGrath and Company in Birmingham. Myself and my colleagues thought we were never going to stop lodging judicial reviews. It was like every week there was at least one judicial review against a local authority, and occasionally against the police as well. And then I was kind of thrashing around in the darkness, really trying to work out what we were going to do about this. And then I was heading out to a site in Daventry, a Daventry District Council evicted this group of travellers. And I was in the office before heading off, and I got a phone call from one of the other great heroes in this area of work, Mr. Watkinson, Dave Watkinson, is sitting back there, and who's now retired. And I'm going to do, I hope you forgive me, I'm going to do a very bad impersonation of him. And so the reception put David through to me before I headed off to the site. And he said to me, "Oh, Chris," he said, I've had a rather remarkable judgment come through. It's called a case called Lincolnshire ex parte Atkinson. Mr. Justice said, I am going to send it through to you in the fax machine. The fax machine, a lot of you guys won't know what a fax machine is. And I said, okay, well, I'm going to wait. I won't head off to the site until I get hold of that. And on the train to Daventry, I read. If you've never read ex parte Atkinson, not only is it a very major judgment in this area of law, but unusually for a court judgment, it's actually entertaining. It's actually interesting. Even for a non-lawyer, it's interesting. It starts for centuries the commons of England. Now that's an interesting start to a judgment. So once I signed up two travellers who had pressing welfare needs that the council has not taken account of, I'd signed them up for legal aid. I remember walking up and down. They were on the Canal Road next to the canal in Daventry. Walking up and down the Canal Road, on the phone, directly on the phone to one of the secretaries in the office, dictating a pre-action letter to Daventry District Council, which largely consisted of me quoting enormous chunks of Mr. Justice, he was then Mr. Justice Sedley, Mr. Justice Sedley's judgment. And they got 6 months on that Canal Road, while Daventry District Council tried to work out what the hell are we meant to do about this. And now forward to now, you won't find a local authority or a police force that doesn't have a written policy on how they deal with unauthorised encampments, on how they look at welfare circumstances and other important matters, and how they should go through the whole processes. And I think it's fair to say that the work done, the judicial reviews done at that stage through the late 90s and into the early 2000s, fighting back against this raft of events that was happening throughout England and Wales, led to a situation where proper processes were taken into account. It still doesn't answer the fact, and I'll come to that very briefly, about the need for more provision. But it led to a situation where proper processes were, most of the time, at least attempted to take place, and that gypsies and travellers did remain on the roadside. I think there was a very grave danger at that stage that they would have been literally driven off the roadside. So whizzing forward to where we are now, very quickly going before that to the importance of the duty to provide sites in the Caravan Sites Act, which was exemplified by a case prior to the repeal of the duty called West Glamorgan ex parte Rafferty. And in that case, the travellers were facing eviction. In fact, there were lots of allegations of nuisance against the travellers in that case. But West Glamorgan Council no longer exists, but the council had failed to provide a single site. And on that basis, the judge said, I'm not going to evict these travellers because you failed in your duty to provide sites, and therefore I'm not going to give you an eviction. And the council then built a site where the travellers were encamped, and that site is still there in the same place. Now, the 350 odd sites that exist in England and Wales today would not have existed without that duty being in place, and have not increased since that duty, roughly speaking, not increased since that duty was repealed. In Wales, there is a duty in the Housing Wales Act 2014 to provide sites. Now, I very quickly mentioned the case, and this is where I'm talking. So I think now that we've got a new government, I mean, I know we plugged away at the you might remember there was a previous leader, and we plugged away at them, and they were in power for rather a long time, about bringing back the duty, and they failed to bring back the duty. But we now have a new government, and it's not for me to tell campaign organisations what to do, but I wonder if this is now another moment in time, combined with some of the things we've been talking about there, with the Wolverhampton case and the stressing in the Wolverhampton case on the need to have you got transit provision, for example? and what Stephen said about transit provision, whether this is another moment in time where we need to go on the campaigning front. We need to go back in and say, let's have another look at this. You know, why isn't there a duty to provide permanent and transit sites and emergency stopping places? And important for the lawyers, what can they do? Or can they just sit there and urge people on? No, I think for the lawyers, there was a case not that long ago called Casey v. Crawley. And in Casey v. Crawley, the travellers were facing eviction by Crawley Borough Council. And I am ending with this one. It wasn't a case I did or any other lawyer I did and you did. So I contacted the solicitor who got the case. And he just got it by accident, and he was totally uninterested in the case. I said, I'm fascinated by this case. I said, can you tell me about it? He said, I don't really know much about it. He said, you can talk to the barrister, So he gave me permission to talk to the barrister, and I talked to the barrister, and it went through to the High Court. And the barrister lost in the High Court, but Mr. Justice Burton said in that case that what was very important was that local authorities should consider alternative locations. Is there somewhere, you shouldn't just do welfare inquiries, is there anyone who's ill, or are there children who are just about to do their exams work? But you must look at, are there alternative locations? And that was an essential part of the whole process. But he decided that Crawley Borough Council had sufficiently to alternative locations, and therefore he granted a possession order. And so after the barrister sent me the judgment, she phoned me up. I remember she phoned me up, and she said, I'm thinking of appealing, she said, to the Court of Appeal. And I said, whatever you do not appeal to the court. Please don't appeal to the Court of Appeal, because the judgment is very useful for what Justice Burton said, even though the travellers in that case were not successful. So I think there is, we already rely on that a lot in cases, and I think we need to ramp up the reliance on that, both in wide injunction cases and in unauthorised encampment cases and similar cases to that, and start putting pressure on with a view to the fact that ever since we've started, I first started dealing with this in 1995, the obvious solution to the situation has been provide them with I like it when the answer is nice and simple. Provide them with places to stop is the obvious solution. Thank you very much.
Thanks so much, Chris, and I'm sorry we ate into your time, because I'm sure you would have told us a lot more wonderful stories. We're now going to, for those who are with us in person, head down to the hub. As I said, as many of you as possible, I hope will join us for some drinks and some food. You will be getting, as I said, a recording of the event. You'll also be getting a feedback form. Please fill it in if you can bear to do so. We'd like to receive the feedback. And yeah, thanks very much for coming along. And I hope we can carry on the conversation and chat to old friends, meet new ones downstairs. Okay, thank you very much.